Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 23-3100, United States of America versus Demetrius Green, appellant. Ms. Runkle for the appellant, Mr. Hansberg for the appellee.
Ms. Runkle, good morning.
Good morning, Your Honors, and may it please the court. Molly Runkle for Demetrius Green. I would like to reserve 3 minutes for rebuttal. In January of 2020, federal law enforcement officers mounted a continuously recording hidden camera on a rooftop as part of a criminal investigation that had nothing to do with Demetrius Green. In clear view of that frame was the back porch of 917 Waller, the home where Mr. Green was staying. A federal agent later received a notification from an AI-based gunshot detection system, alerting her that shots may have been fired somewhere in that vicinity. That agent then accessed that poll camera footage on her cell phone, allowing her to travel back in time to watch a perfect visual recording of the activities behind the home. She did not have a warrant when she searched that camera footage. Under the Supreme Court's decision in United States versus Carpenter, as well as the principles underlying the Fourth Amendment, that action was an unlawful search.
Are you saying the police need to have a warrant to check a poll camera footage?
Yes, Your Honor, unless there is some exception to the warrant requirement that applies, such as an exigency.
So why would they need a warrant for a poll camera that they possess that's only looking at things that are publicly available?
Because, Your Honor, in United States versus Carpenter, the Supreme Court held that once the police start to collect a compendium or a large aggregation of activities that are otherwise public, then an individual may start to have a Fourth Amendment privacy interest. There, for example, Mr. Carpenter was traveling out and about in public, but the cell site location information was a recording of that public information, as the Supreme Court noted.
That was a GPS monitor on the defendant's car. This is a public camera trained on public spaces.
Your Honor,
to be an important distinction.
Your Honor, I think you're speaking to Jones. That's the GPS case attached to the car.
Yeah.
The cell site location information in Carpenter was collected by third-party cell site and was pinging on cell phone towers. Here, I think if anything, the video recording of the poll camera was a more serious intrusion on privacy, not less, for 2 reasons. First, here we're talking about video recording. In Carpenter, the police get dots on a map where the cell phone tower pinged most close to wherever the individual was. Here we're talking about actual video recording.
But I guess I'm trying to understand your argument. It just seems to me that for the cell site location, you needed a warrant because you had to focus in on a particular person, because this is like a big, massive data, and you need a warrant to say, like, we have probable cause to focus in on one person. But a poll camera just seems different because it's just trained on one spot. This one wasn't even aimed at your client. It's just like it's almost like an observation post, which is you just are looking at a public space. And so it just strikes me as strange that the government would need a warrant to look at their own camera that's trained on a public space that's fixed and not targeted any particular person.
Well, as to the fact that this is the government's camera as opposed to something from a third party, the Supreme Court in Carpenter said whether the data comes from the government itself or a third party, individuals maintain a reasonable expectation of privacy in the whole of their public activities in that compendium. Here, we're talking about a compendium of activities in one spot around a home. And while in Carpenter, Mr. Carpenter would have been out and about in public, here we're actually talking about video recording, a much more serious intrusion on privacy, and the fact that this camera captured somebody's home.
The outside of his home.
The outside, yes, that's correct. The back porch, back door, and in fact, Mr. Green was actually seen inside the home through the window in the back door as well. So here, the Supreme Court has reiterated again and again that the area surrounding a home, immediately next to the home, is intimately linked with the home. This is where Fourth Amendment privileges and privacy interests are at their absolute highest. So in this way, I think that the privacy interests implicated here are actually greater.
One of the things the government says is that you shouldn't even be able to raise this argument. That's what the district court seemed to say as well. And our cases seem pretty clear, at least, that you need to be able to show you at an absolute minimum had permission to be on the premises. But it seems like Green's counsel disclaimed any intent to make that argument for understandable reasons, and didn't put on any evidence of having permission to be there. So what's your best response to that?
A couple of things, Your Honor. First, under United States versus Sheffield, a case from this court, it is the government's burden to raise Fourth Amendment standing in the district court.
District court can raise issues on its own as well.
I understand, Your Honor, but I think here it's particularly relevant that the government didn't raise it, given that the government's entire theory of their case was that Mr. Green lived in the home, had everything in the home. Their entire theory was that he was the sole occupant and could therefore be attributed to all of the items within the home. Under those circumstances, I think the forfeiture issue is a little more concrete. But in any event, the district court did take judicial notice of the items on the docket, as well as the evidence that had been presented at an earlier evidentiary hearing on the first suppression motion. That evidence included the poll camera footage showing that Mr. Green would have been in the house at least overnight and then through 12 hours.
The concern is that there's absolutely evidence that he was there. And the question I have is there any evidence he had permission?
Your Honor, I think that cited in the government's detention hearing briefing is a sort of a recitation of all of the evidence in the case. And again, Judge Jackson said she was taking judicial notice of the items on her docket. There was evidence showing that Mr. Green had a more significant connection to the home. They spoke about how his items were around the house, for example. Earlier in the suppression or in the pretrial conference, when the suppression motion was reiterated, the government proffered that Mr. Green had been using the bathroom. The government made a lot of hay in the case that he was making a salad. And I think when you look at this stack of evidence, it's not unreasonable to think he was there with permission. This is not like United States versus Gale, where there was affirmative evidence that the individual did not have permission to be in the home. He did not have the key. The key had been changed. So, given those kind of distinctions, I think there was sufficient evidence.
So can I take you to the evidentiary issues?
Sure, Your Honor, of course.
To assume for the moment that I agree with you that the text referencing marijuana was improperly admitted, can you just give us your best argument that that was not harmless? And in particular, I'm curious what element of the offense you think the jury would have used that for in an improper way.
Sure, Your Honor. So I think that the text was not harmless because it was really the only evidence in the government's case that Mr. Green was a drug dealer. The government didn't put on any evidence explaining how Mr. Green, an indigent individual, came to possess $30,000 worth of prescription pain pills. They didn't explain that he knew what to do with them, that he knew how to sell them. There was just no evidence about that in the case. The only evidence that he had ever offered to sell somebody narcotics was this text message offering to sell marijuana to an unknown individual.
Well, the quantity of the drugs is evidence of intent to distribute, isn't it?
Yes, Your Honor, but in terms of constructive possession, we maintain that there was not sufficient evidence that Mr. Green possessed that quantity of drugs, and the government never.
Just saying that that's not the only evidence of distribution. The text was not, because whoever possessed that large quantity of drugs intended to distribute them, because that's too much for one person to consume.
Absolutely, that whoever possessed those drugs intended to distribute them. I don't dispute that. But in terms of Mr. Green being the individual who was going to distribute those drugs, the government just never answered a lot of those important questions.
So it seems like everyone agrees the key issue was constructive possession. And one concern for your harmlessness argument, that my understanding is that we have to proceed as if a limiting instruction was read that said you can only consider this for intent. In other words, don't consider it for constructive possession. And your theory needs to be that I think the jury disregarded that limiting instruction. Otherwise, the conclusion would be the text can't possibly have affected their consideration of constructive possession, and therefore it's harmless.
Your Honor, there was no
problem
limiting.
with that?
There was no limiting instruction.
I understand that because Mr. Green asked for there not to be one.
Correct.
And I guess, so here's my question.
Thank
Do you
you.
disagree? The government makes the point, which I think is supported in some of our cases, that when you do that, when we consider prejudice on appeal, we have to assume the instruction was given. You can't benefit from your understandable choice not to have this evidence reemphasized. So don't we have to proceed as if a limiting instruction was read?
Your Honor, you're welcome to proceed as though a limiting instruction was read, but that wouldn't cure the issue here. There's a distinction between asking for a limiting instruction saying that evidence was only admissible for a permissible purpose, and our argument, which is that there was no permissible purpose under which this evidence could have been admitted. So I don't think we forfeited anything by saying we don't want a limiting instruction when our position from the very beginning has been that this evidence should never have come in at all for any purpose under Rule 404.
If the text had just said, come support my hustle, would that have been admissible? If it didn't say anything about tree?
I don't think so, Your Honor. I think there would still be.
Why doesn't that go to intent to distribute?
Because there's no evidence that would go to, that suggests that that text message would go to intent to distribute the types of narcotics that were found in the home. The government cites a lot of cases showing that previously evidence has been admissible to show that somebody who's previously sold one type of drug can be admissible to show that here they know
But
how
I'm
to
saying
sell.
Putting aside the type of drug, if there's evidence that this person has previously said, come support my hustle, meaning come support my selling of drugs, how can that possibly not be probative of intent to sell other drugs that he's found to possess?
Well, Your Honor, I think that's propensity evidence. I think that's evidence that he has the character of the drug dealer. He's dealt drugs before, so he dealt drugs here. That's an impermissible purpose under Rule 404.
So what's an example of a permissible purpose? Like, it just seems to me that that's a very straightforward application of this not just being propensity evidence, because the issue on trial is whether he had the intent to distribute, and if he has previously had the intent to distribute. And I don't think there was a huge time difference between.
Not with the text message, that's true.
So how can that possibly, based on your reading of Rule 404B, I don't know what could ever come in.
Well, this court has held that, for example, evidence that somebody has previously distributed crack cocaine can be evidence that here they knew what crack cocaine looks like, they know how to sell it. That helps answer some of those questions that are relevant to the case. Here, the only thing that the text message would be relevant to prove is that because Mr. Green previously sold drugs, he sold drugs today. That's not a lawful purpose under Rule 404.
All right, we'll give you a couple of minutes to reply.
Okay, thank you, Your Honor.
Mr. Hansford.
Good morning, and may it please the court, Eric Hansford for the United States. As all 8 circuits to address the poll camera issue have held, a defendant has no reasonable expectation of privacy in areas of the home that are exposed knowingly to the public. And therefore, a poll camera's installation does not constitute a Fourth Amendment search. That is consistent with what the Supreme Court has said in cases like Kelo and Serralo, which have consistently recognized that visual surveillance of a home is not a search. And that is also consistent with the recent decisions in cases like Carpenter and Jones. Indeed, Carpenter specifically said, we do not call into question conventional surveillance techniques and tools such as security cameras. And so that left those cases in place. As to the—
It sounds like an argument that you just think the mosaic theory could never apply to a poll camera. Is that essentially the argument? Because you have in Carpenter and in Jones, it's exposed to the public.
Yeah, I mean, I think we view the mosaic theory as generally going to a person's movements, which are not the sorts of things that are exposed by a poll camera, because the poll camera is fixed in a single location. And so you can't kind of construct a person's life in the same way that you can, that the court goes through in cases like Carpenter and
It's
Jones.
really about an aggregate of information that you don't normally expect to be exposed. And I might expect my neighbor to take a glance over at my house every once in a while, but I don't expect them to watch me for, I know this isn't this case, but say 6 months straight, just staring at the back of my house. And That is the idea of the mosaic theory, that the aggregate, the ongoing observation of somebody can transform the nature of the observation.
Sure. So I mean, I guess I would initially press back on the notion that a neighbor would only be expected to take a quick glance at the house. I think Judge Lynch in the First Circuit concurrence goes through convincingly how when you are living in a neighborhood and you are exposing your home to neighbors, it would be reasonable to expect neighbors to be noting observations over time and putting together information. You know, one night seeing a fight between spouses, another night seeing the car is no longer there, a few nights later seeing like the kids seeming to go off with one of the spouses. So in other words, it is not like the Carpenter situation where just there's no reason to think that someone would be able to track you all over town. Instead, when you are in this sort of situation, you very much are in a situation where someone could be putting together this information. I think also on the Judge Garcia's earlier questions as to the judicial notice and the reasonable expectation of privacy in this home, the defendant's ties to this home. Just to clarify, the district court did not say it was taking judicial notice of everything on the docket. Instead, it said, this is at Appendix 377, that it could take judicial notice of items on the docket. And what the district court took judicial notice of is what had happened in the prior suppression hearing. It did not suggest that it was taking judicial notice of, for example, the bail motion. And so the bail motion would be far outside the record. The prior suppression hearing did not go into the evidence as to what was found inside the home. And I think it is notable that on Appendix pages 380 to 383, the defendant was given a very fair chance to put on evidence as to his ties to the home. The district court asked
about something that is at least concerning about this.
Sure.
So in order for him to show he had a Fourth Amendment interest in the premises, he would essentially have to incriminate himself, maybe offer a lease or some other evidence of his permission to be there. And that seems unusual to me. Can you think of other situations where in order to raise a Fourth Amendment claim, someone would have to incriminate themselves?
Well, so I think, I guess I'd point to a couple of aspects of that. First is that when a defendant testifies at a suppression hearing, that cannot come in as substantive evidence at the trial for that very reason. And so there are these built-in protections to allow a defendant to make a Fourth Amendment claim and not incriminate himself at trial. And I think this court's decision in Hicks that we cite in the case in our brief is helpful on this. And that goes through how a defendant has to make this showing at the suppression hearing, even if further evidence comes out at trial, that doesn't undo the showing that's made at the suppression hearing. And Hicks does discuss how a defendant can testify at the suppression hearing without having to worry about incriminating himself.
Thank you.
But I think that the theory of standing here is problematic because it suggests that it puts a really big burden on a defendant who wishes to make a Fourth Amendment challenge it seems like you're asking for a particular type of evidence, which is a lease or direct evidence that a person on the lease gave permission for that defendant to be there. That's just a very specific kind of evidence that seems like would be necessary to meet the burden that the district court and you are advocating here. And it just seems to me that if that were in fact required, there would be some direct case law on this, and we were not able to find any.
I think Hicks is direct case law on this that we cite in the brief. But I think this is very much consistent with how burdens work in the Fourth Amendment context, that a defendant is the one who has the burden to initially show that he has ties to the place where he's saying.
He's shown ties, but it seems like you want more. You want permission, which, I mean, we could sidestep this issue by just saying on this record, this evidence, it seems it's a preponderance standard. It seems more likely than not that he had permission given the length of time that he was there. There's evidence showing he was there over the holidays and he was, that he's been there overnight. He seems to be the sole occupant. Even though that doesn't go directly to permission, it seems more likely that he had permission given the amount of time he was there.
So Your Honor, I think that's conflating the trial evidence and the suppression evidence. I don't think we're necessarily making the argument that the trial evidence would have been insufficient in this case, although I think that would be an open question. Instead, the problem is that at the suppression hearing, none of that was before the district court. The district court asks, this is in 380 to 383, the district court asks the defendant, how is it that you're making a showing of ties to this apartment, to this home? Initially, you had suggested this is your home. Now you're saying you were just couch surfing there. How is it that you are showing you have a Fourth Amendment interest in this home? And the defendant's response is, we concede that's a weakness of our motion. We are not putting on affirmative evidence of that. That's on 380 to 383 of the appendix. And so that's what happened at the suppression hearing. And I think that's the record under Hicks that has to be
So
considered.
what evidence links him to the home from the suppression hearing?
Correct, Your Honor. And
No, I'm asking you.
The evidence that links into the home from the suppression hearing is simply his presence there when the police, I guess it's not even his presence there when the police arrive. It's just the whole camera observations of him overnight stepping out onto the back porch and shooting a gun. That's what linked him from the suppression hearing.
So it seems like this standing argument is sticky and would require us to make potentially new law that creates quite a burden, I think, on criminal defendants. And it seems to me that we can assume standing and say that even if there were standing, there was no reasonable expectation of privacy. That might be the easiest way
I mean, I think
to
we,
address this case.
sure. I don't think we're saying this court needs to address standing, yes. And the Supreme Court has explained that standing in this context, although the term standing is sometimes used, it's a misnomer, and really it's not a jurisdictional type requirement in the way we normally think of standing. So there are multiple alternative arguments, and I think this court could resolve it on any one of those.
And it seems too that any kind of sticky issues about poll cameras and extended surveillance aren't really raised by this case where this poll camera was up for only 2 days.
That's correct, Your Honor. Yes, I don't think this court has to use this case to resolve the poll cameras. As we go through, there are multiple potential problems. It's unclear why this would be the curtilage of the defendants, or that this would be the curtilage of the property. And it's the defendant didn't show any sort of subjective expectation of privacy in this area where there's no fences, no shrubs, no shielding. And so, yes, we think there are multiple alternative arguments that this court could rule on here.
Can I just have a few questions about the text message?
Yes, Your Honor.
So it seems to me it was admitted just for the purpose of showing intent. And
I think it's both for intent and knowledge going to knowing possession, which is important in a constructive possession case.
that would be important. I think that at least the district court's order only references intent. So can we just focus on intent?
Sure.
For the moment.
Yes, Your
Maybe
Honor.
it's also
Yes.
knowledge, but for intent, it's hard for me to describe how it's not a propensity inference. It seems like the inference is supposed to be because he was selling drug A at one time, it's more likely he was selling drugs B through D at a second time. And that, to me, is classic propensity reasoning. Why is that the wrong way to think about it?
So this court has a whole series of cases, the Crowder en banc case. Sure.
Can you just articulate how it goes to intent in a way that's not obviously a propensity inference?
Sure. So I think it is that when a defendant has drugs, when we think he has drugs, and the question is, what is he intending to do with those drugs? The fact that he has previously sold them suggests that in this case, that is also his intent at the time that he is holding the drugs. This court's cases recognize this is close to, the intent line is close to the propensity line, but this court has about 10 cases, including an en banc decision, that is drawing this line.
We do have a lot of cases like that. And in many of them, there are sort of additional facts where it is not just a pure inference that because the person sold a drug this time, they're more likely to do it now. In the en banc case, there was evidence that they had sold drugs previously at this location, packaged in this way. Whereas here, it doesn't seem like we have any of those kinds of similarities. It really is just, he said he wanted to sell marijuana, so it's more likely he wanted to sell cocaine. And I don't think, at least as to when the drugs are different, I'm not sure we have a case that is that broad.
I mean, I think that there are repeated cases that are along those lines that involve the same drug. I agree that Mitchell's the only case that involves different drugs from this court, that there are multiple out-of-circuit decisions that involve.
And do you agree that Mitchell is, in a lot of ways, had the kinds of similarities I was talking about? It didn't just say, well, there was this prior uncharged meth deal, and so you can use that for intent. As to Mr. Mitchell, it went into great detail about how it was not just intent, it showed he had previously engaged in a drug transaction with the same person, and in fact done the same thing. And we described it as it was being admitted to show his intent in driving. In this case, it was the drugs. In the prior episode, he was driving proceeds a very long distance. And I can see how when you have those kinds of specific similarities, it almost shades into MO or something other than a pure propensity inference. But here again, it's just he sold marijuana, so he must have sold the cocaine.
Yeah, I mean, I think I certainly agree that Mitchell had additional facts beyond what were presented here. I do think this court's cases repeatedly are saying you can draw this sort of inference just from the fact that the person previously sold the drugs, and it is not a propensity inference. And the fact that it involves different drugs doesn't turn it into a propensity inference. I think that instead of a 404 problem, the question would then go to, is this a 403 issue? Meaning the jury can't help but make the propensity inference. But I think that does not transform it into a 404 problem under this court's cases. And in terms of the 403, what we have here, I think it's notable that this was very carefully litigated below. Both sides filed written pleadings. The district court puts out a written order. The district court recognizes limitations from the fact that it does involve a different drug, but nonetheless says, given the timing, given the language of the text message, it is still proper 403 evidence. And that's the kind of finding by a district court who's sitting at the trial that this court should be reluctant to upset. But even if there were a 403 issue, I think the notion here that the defendant was convicted of possession of a machine gun and tens of thousands of dollars of these serious drugs because there was evidence that he was selling a small amount of marijuana just doesn't really hold water. And notably in this case, in the testimony from the expert says marijuana is legal in in certain jurisdictions. So that kind of lessens any sort of inference from it. It comes out that he's not being charged with selling marijuana. The government in its closing, even though the government's request for a limiting instruction is rejected by the defense, the government in closing at Appendix 1237 carefully limits its argument to the permissible uses as to the text message. And so I think on this record, there's no real way to make a finding of prejudice, particularly given the strong evidence of the defendant's intent to distribute and the defendant's guilt in this case. If there are no further questions, we'd ask this court to affirm.
Ms. Runkle, why don't you take 2 minutes?
Thank you, Your Honor. I just want to briefly respond to some of the government's arguments regarding the poll camera that we didn't have a chance to discuss initially. First, regarding the statement in Carpenter regarding security cameras, that statement has no bearing on this case for at least 4 different reasons. First, the court in Carpenter had no opportunity to consider a camera continuously pointed at a home. Second, that statement is best read as referring to the third-party doctrine. It's in the same sentence discussing the third-party doctrine. Third, this is not a conventional camera. This is a camera with unlimited support on the cloud in terms of recording capability. And fourth, It's not a security camera. This is a camera placed by the police as part of a criminal investigatory purpose. The government also raised the nosy neighbor hypothetical. I'll just note that the Supreme Court in Carpenter at 2219 of the Supreme Court Reporter also mentions the nosy neighbor and draws a distinction between a neighbor who is nosy and the kind of unrelenting, constant 24/7 review that the cell site location information was doing, but that here the poll camera is doing. The government also mentioned curtilage. This is a red herring. The point is that Mr. Green has a reasonable expectation of privacy in the space around his home. This camera undoubtedly captured that space. It captured his back door.
What about the duration? That might be one of the government's best arguments.
Sure, Your Honor. In terms of the duration, I think the logic of Carpenter strongly suggests that 2 days of, this sort of tracking does rise to the level of a Fourth Amendment search. While there, the court in a footnote said it was limiting its holding to 7 days. It didn't say that less than 7 days couldn't qualify. And there, the government had only received 2 days worth of data from Sprint, and the court still held that the data from both wireless carriers qualified as a search. We're talking about accessing footage. I think accessing 2 full days worth of footage is more than an individual would reasonably expect. I know.
So where's the line? Would 1 day be too much?
Well, the court obviously doesn't have to decide that here. One possible way to draw this line would be knots. That's the case concerning the beeper. In the car, the government used the beeper to kind of track a car over, a limited duration over 1 car drive. And the court there said, once we talk about 24-hour surveillance, different principles may come into play. So I think that's one possible line the court could draw here. Frankly, for me, if the government placed a camera looking in my backyard for days, I would feel like my privacy was violated, and I think most Americans would too. Ruling for the government on their first argument would allow the police to put cameras in all of your homes, my homes directed at our front and back doors, look at that footage whenever they want. That violates the reasonable expectation of privacy. Thank you, Your Honors.
Case number 24-1224 et al. Sprint Corporation petitioner versus Federal Communications Commission, United States of America. Ms. Walker for the petitioners, Mr. Green for the respondents.
Ms. Walker, good morning.
Good morning, Your Honors. Helgi Walker for petitioners Sprint and T-Mobile. In this case, the FCC imposed $92 million in civil forfeiture penalties on my clients for privacy violations under Section 222 of the Communications Act. The FCC reached this result by applying an erroneous interpretation of the definition of customer proprietary network information, CPNI, that directly conflicted with everything it had said for the past 25 years. As then Commissioner, now Chairman Carr, put it in dissent, quote, the FCC has reached beyond its statutory authority in these cases. And just 2 months later, the Supreme Court handed down Garcia. That decision controls. The FCC's civil penalty regime violates the 7th Amendment, just like Justice Sotomayor flagged in her dissent. But at a bare minimum, Your Honors, the orders here violate the well-established fair notice doctrine because they are based on, as FCC counsel told the Fifth Circuit at oral argument just last month, quote, a new interpretation of the statute, quote, a new legal rule, and we did not have fair notice of that rule. Finally, the penalties violate the statutory cap. The FCC took what it determined in the liability section of its order to be one continuing course of failure, the systemic, paragraph 48 of the T-Mobile order, systemic failure to have reasonable safeguards. And then when they got to the forfeiture section of the order, decided to break that up into 73 different violations for T-Mobile and 11 for Sprint. Whatever the FCC might be able to do under Section 503, it can't engage in a complete mismatch between the basis for liability and then the basis for the penalties. I'd like to start with the Seventh Amendment question, unless the court has issues it would prefer to focus on. There, Justice Sotomayor said the FCC's civil penalty regime would be upended by Garcia, and we think she was right. First,
But why isn't it true that even if there is a jury trial right in this context, it was provided and waived because it was up to your clients to decide whether they wanted to just get a trial de novo by not paying this forfeiture?
understood, Your Honor. The availability, the theoretical availability of a 504 collection action does not solve the Seventh Amendment problem in this case. And before I get to that, I just want to note that the FCC made zero argument in its brief that we didn't have a civil penalty here within the meaning of that first factor under Garcia, which the court said
So I'm
effectively.
assuming that you do have a right to a
Understood.
jury
I just want to
trial.
point
Why
out.
isn't it that you didn't waive it?
Yes, I
That's
just
my
want
question.
to point out they didn't even try to make that argument. Three reasons, Your Honor. First, there is no guarantee that DOJ will ever bring a collection action under 504. The statute simply says the forfeiture is, quote, recoverable. DOJ doesn't have to do anything at all.
But that's good for your client, isn't it? If they don't.
Well, it's not good,
What?
Your Honor, because we're caught between a rock and an even harder place. We had to choose between seeking review in this court of the legal questions on direct review under 402A by paying the penalty under protest to secure jurisdiction here, just like you told us to do in the AT&T case, or doing nothing, being branded a delinquent debtor to the United States and thinking maybe the Department of Justice would bring a collection action, which would be limited in certain jurisdictions to review only of the facts.
But we just are focusing on this jurisdiction. And in this jurisdiction, you would get a trial de novo.
Well,
all issues, factual and legal.
In passing, in some decisions like Action for Children's Television, the DC Circuit has pointed to the de novo language in the statute, but the Fifth Circuit's holding was
But why
crystal
does that
clear.
affect, I mean, we're the DC circuit. So if something could have happened in another circuit, why does that affect my analysis here?
Because the Department of Justice has nationwide venue under Section 4. DOJ can bring these suits in any district where the carrier's line or system runs. The government, I would be willing to bet, is not going to sue us in a district where we have more rights than we do in the Fifth Circuit or the Ninth Circuit. But we can't be put to that
Are you
kind of a...
suggesting the government's going to bring all of its compliance actions in the Fifth Circuit?
I'm suggesting they have an incentive, like all good
Have they done
litigators.
that since that opinion came out?
Well, there have been very few collection actions, which is another point that I wanted to raise in terms of why this is totally theoretical. We might get a collection action. The Chamber amicus brief does a good job of saying that as far as we can tell, there's never been a jury trial in a Section 504 collection action ever. But the critical point, Judge Pan, is we can't be forced to choose between two core constitutional rights. On the one hand, the right to have a federal court of neutral decision makers like this panel address what we think are the serious legal problems with the order. And on the other hand, the time-honored right to a jury trial. We can't be forced to choose. That's basic under the unconstitutional conditions doctrine and just plain old common sense. You know, there's a
Counsel, am I right that in the Fifth Circuit, you would still have a jury trial on the factual questions, right?
I think so. I mean, I think so. I'm not sure, not been litigated, but
So-
yes.
Right, and even then, so it does seem like you still have a jury trial right there in all the ways that matter.
Well, with all respect,
Don't determine legal questions.
I think all the ways that matter include the constitutional violations, the statutory overreach, the penalty violations, and the arbitrary and capricious problems that this court has before it today. All the ways that it matter under our Constitution includes the law under Article 3 and the facts and a jury trial under the 7th Amendment.
Yeah, and so I take the point about the reputational harms, but as you emphasized, the thing that triggers the jury trial, right, is the civil penalties. And I think the FCC would like us to think about the case as if those civil penalties are not even imposed unless and until a collection action comes.
Yeah.
And so
That
reputational harms and even the collateral use of fact findings, those might be harms, but they don't trigger the 7th Amendment. Why are they wrong?
they are wrong because in paragraph 1 of the T-Mobile order, the FCC quote imposed a penalty on T-Mobile. And then in paragraphs 1 through 9 through 111, they ordered T-Mobile to pay. This wasn't a casual suggestion like, hey, you might be liable, or hey, you might want to pay this $92 million. They ordered us to pay the forfeiture within 30 calendar days and then gave explicit instructions. Because I was curious, Judge Garcia, I pulled the SEC's final order that was on review in a Jarkizi. It maps directly on top of the FCC's order. The SEC did the same thing. They imposed, and I'm quoting, paragraph 115A of the PEDAP in the SG cert petition in
But
Jarkizi.
that statutory scheme doesn't have this different feature,
No.
which is that you cannot pay it and wait for a complaint.
Well, actually,
right?
the Securities and Exchange Act has a provision, section 20, that enforces for non-payment of civil penalties. So it is exactly the same.
Well, it's not exactly the same because I guess we have case law that says you can just do nothing at all and that's just fine.
Well, with all respect, would you do nothing at all if it were your client, Judge Pan? We had to choose. We had 60 days to decide whether we were going to forego legal review in this court or wait for a collection action that might never happen, where we might not have a full
Judge
trial
Garcia's point was that you would still get legal review.
of the
under-
facts.
No, I mean, if they're only doing facts in the Fifth Circuit, you're not forfeiting any legal arguments by not raising them in the district court. Well, why wouldn't you get to do the legal review in the
No,
Fifth
we are,
Circuit
we
as
are.
well as the factual review in the Fifth
Well,
Circuit?
with respect, we would be, because under Stevens, the court's holding was unambiguous. It says you must raise legal challenges to a forfeiture order on direct review under 402A. You may not raise them in a forfeiture order. We had a fork in the road and we can't be forced to choose between those rights. But I want to come back to your questions about 504, Judge Pan, and I want to compare this to Jarkizi. There was no doubt in Jarkizi that the 7th Amendment right attached when the SEC was, quote, seeking, that's 122 of the U.S. Reporter pin site for Jarkizi, because the SEC was seeking civil penalties. And then the SEC levied them. The chief used the word levied. Nobody in that case thought that the 7th Amendment question was somehow premature. The agency had sought to impose the penalties and indeed impose the penalties over our objection, our careful preservation of this issue before the FCC. I find it an odd framing that the FCC has used here of waiver. There was absolutely no waiver of our jury trial rights. If you check the record, we submitted a long supplemental
But it's a
filing.
choice because you knew that you had two options. You could pay an appeal or you could wait for the, I guess, in collections action, and then you would then get the trial de novo on all issues.
No, we would not.
So you made an
Well-
affirmative choice.
Well, with all respect, Judge Pan, we could not. How could we have banked on getting a trial de novo on
No,
all
I
issues?
understand, but the thing is, if they don't bring it though, it seems that,
Mm-mm-mm.
you know, the only injury that you claim does not entitle you to a jury.
I don't think so, Your Honor, because
That is just reputation.
if we had let those 60 days go by, it wouldn't have just been reputational. The FCC has said that it can and it will use what it believes is the adjudicated finding, which would go
Well,
final.
the facts, but not the fact of the NAL.
What I'm
There's
saying,
actually a provision that says we don't use that for anything.
well, the FCC has said in its 1997 forfeiture policy statement that it can and will use adjudicated findings against licensees in future penalty
But these are not
proceedings.
adjudicated.
The FCC thinks it's adjudicated. At paragraph 108 of the T-Mobile order, the FCC said, we find that T-Mobile willfully and repeatedly
Okay.
violated section 222.
So section 504C, use of notice of apparent liability. In any case where the commission issues a notice of apparent liability looking toward the imposition of a forfeiture, that fact shall not be used in any other proceeding before the commission to the prejudice of the person to
Yeah.
whom such notice was issued,
That
unless the forfeiture has been paid or a court of competent jurisdiction has ordered payment of such forfeiture and such order has become final. Doesn't that prevent the FCC from using that NAL as you have stated they would?
So the FCC hasn't made your argument, Judge Pan, but even if they
Wait, I can't
had,
look at the statute.
I'm
that's what
just
the
saying,
statute
it's
says.
adversarial system and they haven't pressed that argument. And the reason why I think they haven't pressed that argument, with all respect, is that that is the notice of apparent liability. That's like a charging document. That's like a Wells notice in the SEC context. The FCC moved on to a final order, the final order that is before you today, and found as a determination, as a matter of liability, that we had violated section 222. And they can and they will, and they have said that they can use that against our company in future license proceedings. Wireless licenses are the lifeblood of any company like T-Mobile's. We could be denied a new license.
So I just want to understand this, Ms. Walker. 'Cause
Yes.
I'm not an expert in
I know,
communications law
it's-
as you are. But it seems to me that what they are saying is that they will not use the fact that they found liability against you unless you actually pay or there's an adjudication. And it seems to me that what you're saying is that the underlying facts can be brought up, but that could be brought up anyway, regardless of whether there's been any of this NAL or finding a forfeiture.
Perhaps I'm not articulating it well, Judge Pan, but when the FCC makes a finding of liability, like it did in the final order, not the notice of apparent liability, when it makes a finding of liability, and I think my friends on the other side would not dispute that they made a finding of liability, that was the basis of the forfeiture order, that finding, when it goes final, can be used against the regulated
The fact
entity.
of the order, not just the facts underlying the order.
The violation, the fact that you violated. So then if T-Mobile were to go to apply for a new wireless license, the FCC would say, we don't think that's in the public interest because you've violated section 222 and you've done all of these
But would
bad
it be
things.
based on the fact that they made the finding or just based on the facts that underlie the findings?
I
It
think
seems
I-
like the facts are fair game anyway, right?
Well, I think the FCC would say if it's an adjudicated final finding, it can be used against us. It can also be a basis for a higher penalty
Does that count
in
as an
another.
adjudicated final finding, though? Like if you do not
Yes,
pay
yes.
an appeal and you do not
Yeah, but
like wait for the thing,
it goes final. That would be like the broadcaster in Illinois Citizens who paid and didn't seek direct review and just let it go final after the 60 days. At that point, you're stuck. At that point, we're stuck with a final adverse order against us. It says we broke the law. We'd have to
I
be
guess I'm-
delinquent on
I'm
our
confused
debt.
about this whole statutory structure that
Okay.
you don't have to pay it. So how
Well-
can it have all of
well-
the significance where you can just wait for the compliance action or the collections action?
Well, I don't think the FCC told us we don't have to pay it. A paragraph.
But that's the way this whole structure works. You can either pay it and appeal, or you can just not pay it and wait for the collections action. Like
We-
our case law says you can do so. You can do nothing, and that's perfectly fine.
At risk of losing our Article 3 right to have a federal court review
So
the
now we're
substantial
talking in
legal
circles.
problems, but it's not a legitimate choice, is what I'm trying to say. It's a false choice. We can't.
That's not what I'm asking you about now.
Okay.
I'm just saying you're trying to say that there's so much significance that they found that
Yes.
there's this apparent liability.
Yes, it was
And I'm
so,
trying to say that it is not what you seem to suggest, that it is
right.
this finding against you that's out there against your client when you don't have to pay it. That's what I'm saying.
Well, whether we pay or not, I understand your question, I think. Whether we pay the forfeiture that we were ordered to pay or not, the FCC's finding of liability still stands. It goes final if you let the 60 days to petition for review lapse.
No, I understand
Then it
that. I'm
goes
just trying
final.
to understand the significance of that.
The
I'm having
signific-
trouble seeing why
Yeah.
it's significant if you don't have to pay it.
The significant,
And they can still use the facts
Right.
one way or the other, whatever they found.
it's significant because we've been told that we've broken the law, and the FCC can use the finding that we have broken the law against us in other proceedings. It also imposes reputational harm and subjects us to disclosure obligations, but we shouldn't have to be, I mean, the FCC said, pay us in 30 days. A 504 action is a collection action. It's for delinquent debtors. We are good corporate citizens. We don't blow off our debts to the United States. We pay, the FCC said to
Just a
pay within
clarifying
30
question.
days, so we did.
If you do wait for the collection action, is there some monetary penalty for you putting the government to that burden? Is interest running? Are there other penalties for delay?
I'm
payment?
not sure, but I think interest does run.
Okay.
But we have no control, again, over whether there ever is a collection action. We have no control over where that's brought. Any good litigator would bring it in the Fifth Circuit or the Ninth Circuit or some other circuit where they thought government might be able to prevail on that score. If the court's interested in hearing about statutory authority in the time that I have left, I'd be happy to quickly address that.
Any questions? We'll give you a couple minutes in reply.
Okay, thank you so much.
Mr. Grimm.
Thank you, Your Honors. Good morning, and may it please the court. I'm John Grimm on behalf of the FCC in the United States. Sprint and T-Mobile's right to a jury trial was not violated in this case. Under the Communications Act, they were not required to pay any monetary penalty, which is the focus of Garcia, unless they first had a de novo trial in district court. And while they chose to challenge the commission's decision directly in this court, that was their choice. It was not mandated by the statute that they claim is unconstitutional. I'd like to address several of the arguments that we just heard from Sprint and T-Mobile regarding why the existing procedure is insufficient. The first, well, I guess really the first two are that they have no guarantee over when this proceeding might be initiated, and that this would somehow cause them to be branded a delinquent while they're waiting. This court has answered that question in both Public Broadcasting and Action for Children's Television, where the court held that if a party is suffering a demonstrable injury as a result of some delay or failure to expedite a collections action, they could bring a declaratory judgment action themselves, and that would trigger the same level of review that they would get under Section 504. I'd also like to address the argument we heard that all of the points we're making about the FCC's statutory collections action would have applied to the SEC as well, because I don't agree with the carrier's reading of the relevant law there. In their reply brief on page, I believe it's page 6, they cite a Southern District of New York case. I'm going to attempt to pronounce it. I think it's Gerasimowicz, but it's on page 6 of their reply brief. That case outlines to some extent what an SEC collections action looks like. And it cites a Ninth Circuit case called SEC v. McCarthy, which goes into even greater depth. Those cases make it abundantly clear that when the SEC imposed a monetary penalty, the collections action was a summary proceeding. There is nothing remotely to suggest that it was a de novo trial that would entitle them to a jury. So the analogy to the SEC collections is, I think, incorrect. And I would also note that they cite several statutes in their reply brief on page 6, which they cite for the notion that there would still be a collections action in the SEC context. Those statutes relate to the enforcement of a court-imposed judgment under, as you recall from Garcia, the SEC could either do an in-house ALJ proceeding or it could go trigger a district court action directly. The statutes they cite in their reply brief refer to the collection of a court-imposed judgment if they went directly to court. That ALJ in-house versus court distinction, I think, is also significant because it relates to Justice Sotomayor's dissent in Garcia that we heard about when she talked about how that opinion would call into question SEC enforcement action. I believe she was talking about the FCC's ALJ proceeding, which is different from the proceeding that was at issue here, and it does not contain the de novo trial right.
One of the arguments Sprint made is essentially that assume the Fifth Circuit rule is the rule everywhere. That yes, there is a right to a trial of the factual issues de novo, but to get to that, you have to waive your ability to seek review of all of the commission's legal determinations. Why isn't that a concern? It's not exactly a free choice to go to a jury. You've got to waive all your objections to the legal determinations.
Sure. So several points in response to that question, Your Honor. The first is that I think that post Garcia, it's questionable whether that decision by the Fifth Circuit would still stand. Obviously, this court can't change that, so
Right.
we'll assume that it says what it says. What the carriers are asking this court to do is essentially invalidate as unconstitutional a statute based on their concern about what a hypothetical future case in a different jurisdiction might look like. If they are sued for a recovery action in a jurisdiction where they believe the law does not adequately protect their jury right, I think that the process would be for them to raise it in the first instance in that district court. But here, that never happened. They paid the penalty directly so that they could get to this court. And again, I believe, under Pleasant Broadcasting and Action for Children's Television, I think if they did have a concern that the way that the government was going to bring a collections action might create a problem for it, I think they would still retain the right to bring a declaratory action and get the full judicial review that they think they're entitled to. So I think the concern about how a different jurisdiction might apply the law in an unknown case, I just don't think is a sufficient basis for this court to decide that the FCC's enforcement statute is unconstitutional. I also would like to briefly address this question of waiver because I know that the carriers dispute whether or not they've waived their right to a jury trial. And I just want to highlight that this court in Illinois Citizens Commission for Broadcasting, which we cite in our brief, described it in terms of waiver, saying that a jury trial was available but waived. I don't know that it's necessary to get into whether this was a waiver in the sense that, if they elect a jury at trial, the court says, no, you waived it. I think what's important here, what the court is talking about is they had the option to get a de novo trial and they chose to forego that option, whether you want to call it a waiver or just a decision to opt for a different procedural route. That's what they did here. Your Honors, I'm happy to continue discussing the Garcia issue to the extent the court has questions. If not, I would like to turn to the statutory construction if that would be something that the court is interested in hearing about.
One thing I'm just wondering, right, is if we told in federal court, you have a Seventh Amendment right to a jury. We have a new rule. In order to get a jury right, you have to waive your right to appeal any legal determination I make. Kind of seems like you're putting a pretty substantial burden on invoking your right. And if the Fifth Circuit rule were the rule everywhere, this case would seem similar to that.
Well, it might, Your Honor, but the Fifth Circuit rule is not the rule everywhere, and it's certainly not the rule here. In this circuit, they do have the right to challenge the underlying decision. They acknowledge that in their brief.
Is that necessarily how the Fifth Circuit rule works? Because it just wasn't clear to me that the import of that meant that no legal findings or legal rulings could be appealed. It's just like the facts would go to trial, but does that mean you can't still make legal arguments on appeal?
I don't think it does mean that, Your Honor. So I think that what the Fifth Circuit held is that the district court doesn't have jurisdiction to challenge or to hear a challenge to the legal validity of the FCC's order. But I don't see why, once that district court order is a final judgment, it wouldn't be appealable just like any other final judgment of the district court. And presumably that would allow them to raise any challenges that they thought were wrong with the were wrong with the way that the trial was conducted, including the legal issues that were raised.
But also legal issues not raised at trial. It just seems that that's not a subject of the trial, but I don't think you could deem legal issues waived if they weren't, or forfeited if they weren't allowed to raise them in the trial. It just seems that just like this court can now look at the legal issues without a trial, the Fifth Circuit should be able to do so in whatever they're doing in the Fifth Circuit.
I would agree with you, Your Honor, that if the court doesn't have jurisdiction to hear a legal issue, that doesn't mean that the party has forfeited it. So I
just want to make sure you understand the Fifth Circuit rule is that if the party is in a trial proceeding, it cannot raise challenges to the legal validity of the FCC's order, right?
That's how I understand the Fifth Circuit law, correct, Your Honor. As I said, if the court would like, I would like to address the statutory arguments as well, because I think that under Carrier's reading of the CPNI rule, they would essentially read it entirely out of existence. Wireless carriers like Sprint and T-Mobile have a unique relationship with their customers, and that exposes them to tremendously sensitive information. Congress instructed those carriers to keep that information safe. Under the carrier's argument, that exact same information would no longer be protected simply because, in addition to offering wireless voice services, the carriers also offered data service. And I think that it is not, I just don't think that there's any way to read that statute as though Congress intended it to be so self-defeating. The key language in the definition of CPNI, the carriers have focused on this solely by virtue language, but I think that the key language that solely by virtue modifies is relationship. It's solely by virtue of the relationship that the carrier and the customer have. And I don't think that there's any dispute here that the relationship between Sprint and T-Mobile and their customers is the sole basis by which they had this information. So
it seems to me that there's a carrier-customer relationship. Carrier refers to, I guess, telecommunication services. And there's this other sort of data aspect of it. But just because the carrier or the telecommunications company is offering both telecommunications and data services doesn't mean this is no longer a carrier-customer relationship.
that's certainly the commission's.
And if it's still a carrier-customer relationship, certainly all of this is based solely on that relationship.
Yes, that's absolutely the commission's argument here. I think that's the best reading of the solely by virtue of the customer carrier.
Question about the penalties. I'd just like to hear your explanation of why the statute talks about a single act or failure to act. How do you explain why the relevant act here is, third party by third party as opposed to the overall failure to have safeguards?
Sure, Your Honor. I think that each third party had access to customer data through a unique set of circumstances. Certainly, T-Mobile at least had the ability to review and pre-approve any use case. The carriers had an individual ability to turn on or off at the third party level access to data, which we saw happen when the Securus story broke. And so at any particular moment in time, any third party's access to customer data was its own unique circumstance. And the carrier's failures really were failures with respect to each individual third party.
But it seems like a lot of those third parties abided by the honor system. They actually did get the customer consent. So it seems like now that you're breaking it down sort of carrier by carrier, it seems like some of them actually did what they were supposed to do, right? Or at least they weren't caught not doing it.
I think that's fair, Your Honor. And I think that it's important I'd like to emphasize sort of what specific violation the commission found. It wasn't that each of those carriers misused the data. It's that the carriers, or that each of those third parties misused the data. It's that the carriers failed to take reasonable steps to make sure the data was being protected. So for each one of those third parties, the carriers claimed the right to conduct audits. They claimed the right to review use cases. But it turned out that they really weren't minding the shop. And what the commission found, as you used the phrase, the honor system, that wasn't enough because it allowed some predictable abuses to take place. And so
I understand that. And I think that that's a reasonable thing for the commission to do. But on the other hand, I think the carrier's position is that in the vast majority of cases, the system they had in place seemed to work. It seemed that even though they weren't taking responsibility for it, a lot of these third-party carriers were getting customer consent before releasing this information. And that just makes it more, I think there are two different ways of looking at this. I don't think that what the commission did is necessarily not reasonable, but I think they raise a strong argument that their reliance on the honor system was not crazy, given that in the vast majority of cases, it worked. And so this seems like a pretty harsh penalty, given that in the vast majority of cases, what they did was fine, or apparently fine.
well, Your Honor, let me get at it from this angle then. While it may or may not have been reasonable to rely on most of these companies, following the rules, and it sounds like many of them did, what the commission found was unreasonable is that when it became public that there was this vulnerability that allowed certain third parties to misuse data, that the approved use case system could be manipulated. When these failures became public, the commission found that the carriers didn't take adequate steps to investigate the extent of the problem, to determine whether or not it affected other carriers. It didn't take steps to make sure that the customer consent procedures were valid. And, and again, this goes somewhat to their argument that they were penalized for not shutting down the entire program. That's not accurate. They were penalized for not taking adequate steps really of any kind. And so I think that once it was made known that the Securus incident occurred, I think that the reasonable, what that put them on notice of was the potential for serious problems, and their reaction was.
But the question is just whether that lapse is one violation versus one across every carrier. And it just seems, did they treat microbilt the same as all the other carriers? Because basically the formula they did was $40,000 for the first day you didn't implement something more effective, and then $2,500 for every day after that. And it does seem strange if they would treat microbilt, where there actually was a misuse, the same as every other company. Did they treat them the same?
Yes, Your Honor. It was every third party, as you said, $40,000 for the first day and $1,500 for each additional day. Interestingly, I don't believe that the carriers challenge either of those numbers. I don't understand them to be saying that the $40,000 for the first day was a problem, or that.
No, that's not my question either. I'm just saying, like, the fact that you're doing it carrier by carrier versus it was a lapse not to implement something better. And once you're going carrier by carrier, it does look a little arbitrary to treat microbilt the same as everybody else when they actually misuse the data and the others didn't. And then my other question is, what about this variance? Like, what's the basis of 100% for one and 75% for the other? That seems plucked out of the air.
Well, Your Honor, all I can say to that is that there's a number of factors that the commission looks at when it makes these adjustments.
No, I understand, but how do you get to 75% for one and 100% for the other?
That's a discretionary determination by the commission based on, all of the facts that it looks at, the level of culpability. And, I just think that that's a judgment call that the commission has to make, and that the regulations and the statutes are set up to allow them to make.
I see, but it just seems to take away from, you've come up with a formula, and the formula seeks to make this something somewhat logical and analytical, and then you can tack on any variance you want to double it or make it 75% greater. I mean, that does seem a little like it gives the commission a lot of power just to make these penalties whatever they think they should be.
Well, Your Honor, I certainly think that the commission has great discretion here, and they found that the carrier's conduct in these cases was particularly egregious, which justified the upward departure. I certainly take your point, Your Honor. I think it's ultimately just, it's a matter.
Any explanation as to why one is 100 and one is 75%?
The orders don't discuss the penalties with respect to other carriers' penalties, so they don't, no, there's no.
But I mean, I guess T-Mobile was 100%, I think, and Sprint was 75%.
Correct.
So why those two numbers for each of those carriers?
The order doesn't explain why it was, 75% as opposed to 100 for Sprint, and why it was 100 as opposed to 75% for T-Mobile. For each carrier, it's the multiplier is justified only with respect to that particular carrier and the level of egregiousness of their conduct.
And you don't think that they should have to just say why they chose 100 versus 75 or 50 or 25?
Well, I think that they explained holistically what their calculation was and the factors that they considered to get there. I don't know that they necessarily are required to explain why the number for one carrier would be.
Well, just why is it 100 for this carrier? It just seems, isn't it by definition arbitrary to pick 100 and not say why it's 100?
Well, I don't think that they justified it by pointing to the egregiousness of the carriers.
No, I understand, but why 100? It's egregious, we should do a variance, but why 100 versus 200 or 300 or 50?
Your Honor, I doubt that they didn't specifically address why it was 100 versus 75. So,
So why is that okay?
Why is that okay? Well, because I think the court has to look at the overall total forfeiture to determine whether it's reasonable. And I think that in this case, given the the egregiousness and the duration of the carrier's conduct, it warranted a significant upward adjustment. Your Honor,
All right. Thank you.
all right. Thank you, Your Honor.
Thank you, Your Honors. I do have 3 points I'd quickly like to make, and I'll be as efficient with my time as I can be. First, on statutory authority, Mr. Grimm just said that this information was covered because of the relationship, but that's not what the statute says. The statute says the carrier-customer relationship. That is the common carrier voice services relationship. And when a wireless company is providing both voice and data service, you asked about this, Judge Pan, isn't it still part of the carrier-customer relationship? Respectfully, no, under the definitions in the Communications Act.
So it's no longer a carrier-customer relationship if they also provide data?
Yeah, or if there are data-only plans, and the
I
reason.
understand data only, but why,
Yeah.
if there's a carrier that provides both,
Yes,
it's definitely a carrier-customer relationship.
it's in
But why does it cease to be a carrier-customer relationship if they also provide data?
for 2 reasons, Judge Pan. 153.51 in Title 47 says in the definition of a telecommunications carrier, and this is a little technical, but really important to this whole area of the law and this case, that a telecom carrier shall be treated as a common carrier only to the extent that it is engaged in providing telecom services. So where we are not providing telecom services, we are not a common carrier, we do not fall under Title II, and we definitely don't fall under Section 222.
But does that answer why a carrier-customer relationship changes and is no longer a carrier-customer relationship if the carrier provides both telecom and data?
Because we're wearing two hats, essentially. We are wearing a common carrier hat to a limited extent, but where we are doing other things, we can only be treated as a common carrier to the extent we are doing.
No, I understand what you're
Voice
saying, but
service.
the specific wording of the statute is carrier-customer relationship.
Yeah.
And I'm
yes.
wondering why a carrier-customer relationship changes if the carrier also provides data services.
Because
It's definitely a carrier-customer relationship because they are providing telecommunication services.
Well,
And if you add on to that, why does that change the relationship?
right. Well, as an initial matter, there are some customers who have data-only plans. They're not in any carrier-customer relationship at all. But for customers that have both voice and data, we are in the carrier-customer relationship under 222 when we are providing traditional voice services. But we are in a information services customer relationship when we're doing data. And the information here partook of
So
both.
you think the statute should have said the carrier and data provider services dash customer relationship?
Well, with respect, it didn't need to do that, Your Honor, because the definition of telecom carrier tells us that when you're doing both kinds of services, you only fall on the common carrier side of the line when you're doing the common carrier service. But there's another reason why, Judge Pan. The statute says solely. Congress really tried to lock this down.
I'm focused on the relationship because I think it is
Yes.
solely because of the relationship. And I don't understand why
Well-
it's no longer a carrier-customer relationship if data is also supplied. Because I understand the distinctions you're making, but we have to focus on the relationship.
Yeah.
Is it a carrier-customer relationship?
Yes, we are not in a carrier-customer relationship when there's data information. And 15351 tells us that. This court's decision in Mozilla, one of the net neutrality cases, explains the difference between telecom carrier status and information service status. The Sixth Circuit just explained it in the other case. I would like to get to the fair notice point, because even if you are not persuaded by our absolutely exciting and correct statutory argument, we do think that at a bare minimum, a narrow holding here is that we didn't get fair notice of that. The FCC, my good friends, have told the Fifth Circuit that this was a new legal rule, the definition of CPNI, that was announced for the first time in this proceeding. It went against everything the FCC has ever said about the scope of CPNI for literally the past 25 years. So whether or not it's a permissible reading of the statute, it's definitely not one that we knew about. The FCC, on top of contravening its past guidance, refused to give industry any clarity when we asked for it. They knew that industry was reading the statute this way. We filed many, many comments saying 222 only applies to voice services. And the FCC sat on its hands for 8 months after it learned of the Securus incident and did absolutely nothing. So I think if you stack up those 5 factors, we had at least a reasonable reading. The FCC's new reading goes against everything it ever said. It knew industry was reading it this way. They did nothing, and they refused to give us any clarity. At a bare minimum, that does violate this circuit's well-established and seminal fair notice precedents. On penalties, my friend on the other side said that the carriers failed to have reasonable means, and that's our point on the penalty analysis. Whatever an agency might be able to do with respect to civil penalties, our modest proposition is that it cannot, on the one hand, find liability based on a systemic failure to act. And then when you get to the penalties section, say, oh, it's not one failure, it's 84 different failures. There never was any aggregator or provider by provider analysis in the liability section. And then they completely switched gears when they got to the penalty section. There is no limiting principle to the FCC's view of what they can do under Section 503. They said in the order, well, you're lucky because we could have used customers as the denominator for the penalty. that would have resulted in forfeitures in the amount of several $100 trillion. Our national debt is only $36 trillion. That can't possibly be right. Finally, Judge Pan, you were asking some questions about why the penalty isn't arbitrary and capricious. We think that it is, and I heard Mr. Grimm concede that the orders do not explain why this, one of the highest penalties ever in the history of the FCC was proportionate and rational in light of the kinds of penalties they have historically imposed. Those penalties have been historically imposed for fraud and actual harm. I will remind you, there's no allegation of fraud. There was zero findings of any actual harm here, and they never explained that. Your decision in Friedman is on point on both scores. Unless the court has any other questions, I will take my seat.
Thank you.
Thank you so much.
This honorable court now stands adjourned until this afternoon at 1:30 p.m.